call this meeting of the Wausau Ethics Board to order. Would the clerk please call the roll?
Dexter?
Here.
Hostler?
Here.
Voss?
Here.
Kearns?
Here.
Thank you. We have all members present. The time is 3:32 p.m. on October 3rd. I also would like to welcome members of the public and other observers. We have attorney Eric Larson representing the board present by video conference, and attorney Andrew Erlandson representing the respondent present online as well. The first item on the agenda is status of proceedings in the matter of the pending complaint against Mayor Doug Dinney. At the September 12th meeting, the board decided to schedule this meeting 1 week before the hearing on the complaint. This meeting could deal with any developments subsequent to the Common Council's decision to authorize funding for further legal representation by Attorney Samuel Hall for the unelected city officials and the city itself in this matter. Additionally, at that meeting, it was suggested the board could, at this meeting, discuss procedures for conducting the hearing on October 10th. The next item on the agenda is consideration and possible action concerning pre-hearing procedural matters, discovery, and subpoenas in the matter of the pending complaint against Mayor Doug Dinney. Attorney Larson, I understand that the respondent's attorney Andrew Erlandson and attorney Sam Hall scheduled depositions for the city clerk and the city attorney for October 6th. Is that correct?
That's my understanding. I've been copied on their email exchange, and yes, that's my understanding.
Thank you. The board appreciates those attorneys proceeding in good faith to accomplish the depositions at long last. In addition, since our last meeting, complainants retained legal counsel, Douglas Poland of the firm of Law Forward. Attorney Larson, Attorney Poland has been in touch with you about his client's position about participating in these proceedings, has he not?
He has.
And I don't believe Attorney Poland is present here tonight or this afternoon, I should say, or by video conference. Attorney Larson, have you provided to the board members and Attorney Erlandson a copy of Attorney Poland's letter to you dated September 8th? September 8th. Is that the right date?
I provided it to Attorney Erlandson. I provided it to Attorney Sam Hall, and I provided it to you, Mr. Chairman. Whether I provided it to the full board, I don't recall. I think I did.
It was my understanding. I see some head shaking. There's no letter from Attorney Poland that you received by email?
I have not received that.
Well, unless it was that initial one, how many letters has there been? Just the one?
I think there's just the one.
Just one.
Yeah, and then
Right.
we did get a copy of that before our last meeting.
Oh, it was
okay.
before the last meeting. Okay, yeah, sorry. I thought there was some communication between then and now.
I'm sorry. I probably added to the confusion, so
Okay.
thanks for straightening us out there again, Robin. Next, it seems appropriate for the board to revisit the issue of subpoenas. The clerk and city attorney have, as noted, agreed to sit for depositions next week by the respondent's legal counsel. I believe that's October 6th. That being the case, it appears the clerk and city attorney can testify at the hearing. Any board members see any reason why those subpoenas the subpoenas for the city clerk and the city attorney should not remain in effect? I see no one suggesting that to be the case. Then also on that subject, Attorney Hall just today notified Attorney Larson that one of the witnesses we have subpoenaed for the October 10th hearing contacted him about being excused or somehow not having to comply with the subpoena, perhaps because of plans for the holiday weekend. Attorney Hall, it's my understanding, speculated that there may be other subpoenaed witnesses who also have made plans. And he complained that there was insufficient notice prior to the hearing date, and he intends to file for a protective order next week, which I believe would delay a hearing if successful. I guess I'd just like to note, and we'll open this up for some more free-flowing discussion, but I would just like to note that these subpoenas that got issued, that went out today, didn't come out of the blue. Subpoenas were issued to all of the witnesses some time ago. I don't remember when that was, but some time ago. So this is not like this is some big surprise and, oh, gee, we made plans, we shouldn't have to, we made plans for the holiday weekend, we shouldn't have to show up. I'm not very open to the idea that we should have another delay here. You know, I think it's time to get this thing dealt with. And if he, I don't know exactly how he would seek a protective order. Maybe Attorney Larson can tell us, you know, where does he go? Does he go to circuit court? Is he going to seek a protective order from us? What can you tell us about that, Attorney Larson?
I guess I assumed he would file his motion for a protective order with us, but I'm not sure. He did reference filing a protective order.
Yeah, yeah.
Motion for a protective order, rather.
So I guess he can file what he's going to file next week. The question for us is whether any members of the board think that there's a need to now take some action on this letter that Attorney Hall sent to Attorney Larson. But as I was indicating, I'm just not very open to that idea because, again, these are not a big surprise. Everybody knew there was a hearing, and we had to reissue subpoenas with the new date on, but the new date should have been public knowledge. And besides that, all of these people, as I said, received subpoenas considerably earlier, so you would think they would have been on the lookout for. I mean, that's not to say we couldn't or shouldn't have gotten the new subpoenas out earlier, but I don't think there was any great surprise here to anyone. I guess I have one other question for Attorney Larson. Is there some kind of minimum time limit for issuing subpoenas? There is, I'm not aware of it.
I also am not.
Okay, so I think that,
it's
you have more on that? Okay, I think just the fact that this has been pending for quite some time and subpoenas were actually issued to all those people earlier really takes away that unfairness because of surprise element. I'd like to hear from the other board members on this issue.
Well, I guess I don't know what's going to be in his motion, obviously, until he files that. But my understanding is that, right, subpoenas could be issued at any time. So I'm not inclined as well. I guess I would just agree with you.
Yeah, I mean, certainly you don't have to say how you would vote on a particular motion that might be brought before us, but just to get a sense of the board, I'm not real open to that idea.
I think I would like to, if we can, continue on the process and still have the hearing on the 10th. So barring any impossible conditions for that, I'd like to see us move forward.
I guess one other thing I'd like to state is I'm not sure that holding it on the 10th was all that exciting an idea to board members either. I sense that some of you may have had plans for starting the holiday weekend early. But we're all here, we're all planning on, we all agreed to do it at that time. And for somebody to say, gee, you know, we wanted to start our holiday weekend early, should we really have to attend a hearing? Well, most of these people are city employees or city officials as well. So anyway, well, we'll see.
Mr.
Yes.
Just to put one other thought on the table, the protective order would likely result in a new date, but we can't agree to a new date unless the respondent, for the terms of our ordinance, petitions for the later date. So we would need the respondent to agree to extend it beyond.
Yes, thank you. That adds
So
to
just to keep that in mind.
yes, I appreciate that. I think we do need to keep that in mind.
So would this be more of a cross that bridge when we get that far and just maintain the 10th as the date for now?
Yeah, that would be my suggestion, unless somebody has a motion to do otherwise. All right. And then finally on this subject, I'd like to ask if the board members wish to consider either issuing additional subpoenas or rescinding any subpoenas that were previously issued for any reason. I would expect not, but, I don't want to take for the board's preferences for granted. I'm not seeing anybody jumping at that issue. The next item on the agenda is discussion of and possible action on procedures to be followed in conducting the hearing in the matter of the pending complaint against Mayor Doug Dinny. Now, I've been thinking about that for a while, and I think I mentioned at a prior meeting that I've worked on some ideas for that, and I've gotten the assistance of Attorney Larson with that. And what I'd like to do now is just hand these out. It's not really necessarily a formal proposal. I suggest we take the items kind of one by one, see if there's a consensus, and then maybe at the end, vote on the whole thing. But let me distribute this now. Thank you, Cody. And the idea here is these would just be the kind of rules we would have for this hearing. It's not a rule that the Ethics Board would be adopting as a permanent rule that would require the approval of the Common Council. It's just for this hearing. See how it works. Maybe it'll result in some permanent rule. It starts out with seating. Just a simple matter. Where's everybody going to sit to make this thing seem to work out properly? And in thinking about it, I would suggest that Attorney Larson would sit where the city attorney would normally sit. I would sit up kind of in the center of this whole conglomeration of things where the mayor normally presides over council meetings. And then the three other board members here would all sit on that side, the north side of this horseshoe of seats. And then the witness would sit where I am right now, by my suggestion anyway. And the respondent and his counsel would sit to the right of the board members, kind of where that microphone is on that flat table there. Maybe we take the podium down. So that's just it for seating. Anybody have any comments, thoughts, concerns? Does that sound reasonable? Seeing nodding. I'm not seeing anybody raising their hand. Raise your hand if you want to be heard, please.
I will make a note, we cannot remove the podium.
Cannot, okay. I'm a little concerned that the respondent and his counsel would be kind of hidden from a good view of the witness. I don't know if there's a way to get another smaller table in alongside it, or maybe they could sit, maybe it'd be better if they sat over on this side of that podium.
I think they could make that choice as
Put
what's
them as a
comfortable for
choice.
them. Yeah.
Yeah, whichever they prefer. That makes sense to me. All right. Then I would like to read a statement at the beginning of the hearing on decorum. Basically, the basic message is just that we've had wonderful, respectful, attentive attendance here by the people who've been coming on a regular basis, and we look forward to seeing that continue for the hearing. If there would be some disruption, Attorney Larson and I have discussed how we could handle that, but hopefully we don't ever have to even get into it because we just continue to have a great attendance here. And unless somebody has some objection to me making a statement like that, I wouldn't think so. Then procedures. We wanted to address things like who presents witnesses first, and even the order of board witnesses and procedures for getting testimony. So as far as who presents witnesses first, if the complainants are in attendance and they want to present something to the board, we would give them that opportunity. But board witnesses would then be first, followed by respondent witnesses. And then if we jump beyond the names of the potential witnesses and get to the procedure, for the sake of efficiency, we would have me asking the questions first, so the chair would call the board witnesses. Designated board member or board members would administer witness oaths or affirmations, and we have that authority under the statutes and the ethics code, so.
Question here.
Yes.
Is this the sheet that was supposed to reflect that?
Yeah,
Because it's entirely different.
I see that.
Thank you.
We have one more of those. I gave Doug a different sheet. Is there an extra? Sorry about that, Doug.
Okay. No, I should have noticed it earlier. It was kind of strange.
Doesn't help when you don't have the specifics in front of you.
Right.
Okay, so unless there is an objection, let's see, where did I leave off? Okay, skipping up beyond the witnesses, the chair would call the board witnesses. Designated board member would administer witness oaths and affirmations, right? And my own thoughts on that, I don't know how you guys feel about it, but my own thoughts are that we could do, I'd like to see you all participating. And so I'd like to have you rotate who's going to administer the oath or affirmation to this witness. So pick whatever order you want, and then we'll just follow that. As we go from witness to witness, we would have a different one of you administer the
My
oath.
question about that is we're being told the procedure because I'm not sure that you say go do this. So how do I do it?
Oh,
What do we do to administer?
turn to the second page.
Okay, it'll tell me how to do it.
The actual language for the oath is there.
Right.
You might want to type it on, with
That's
bigger
okay.
type. That might be
If
helpful.
I get to keep this,
You get to keep it, yeah.
then that'll work.
You get to keep it. Good question, though. Yeah, it's on the second page.
I'm not really experienced at this, so let's tell you.
I tried to think of as much as I could here, so cover as many bases as possible. And so that was, I like that idea of rotating. I don't know, any of you have any concern about?
No.
Or
No, I think it's probably beneficial to
Right.
everyone. That way everyone gets kind of a break from having to administer it, and it gives each witness an opportunity to have someone else.
Yeah.
Yep.
It doesn't seem like too much to ask either. So the chair would call the witnesses. The witness would be sworn or give their affirmation. The chair would then question witnesses first, with other members then permitted to ask follow-up questions if they have any upon recognition by the chair. So hopefully I'll ask a lot of the questions you might have had in mind, but if there are any leftovers, raise your hand. I'll recognize you, and then you would be able to proceed and ask additional questions.
Just a quick, sorry to interrupt.
Sure.
Are we going to get copies of the transcripts of the depositions? Or will they not? I assume they wouldn't even be prepared in time. Or whether that's something that would be presented to the board.
Maybe Attorney Larson could enlighten
So I
us?
think as a practical matter, the answer is no.
Okay.
Because it's not going to be done in time,
Yeah.
I'm sure. But even if it were, I don't know that we have any right to require them to provide that.
Okay. Okay, thank you.
Thanks. Then next, Respondents' Council may then question the board witnesses, with board members able to ask any follow-up questions if there are any. And next, Respondents' Council may question his witnesses, with the board chair and the members' questions to follow, followed by redirect, if there is any, by the respondent. Evidentiary objections would be ruled on by the chair after advice of the board counsel, which I expect to rely on quite a bit, except that other board members may request discussion, in which case a ruling would be made by a board vote. So if you think I'm headed in the wrong way, even after talking to Attorney Larson, raise your hand, be heard, let's talk about it. And then we would have a board vote. Because it's really a board decision is really what these things are, but they have to go around and do round robin every time there's a question about something.
Every time there's an objection that needs to be
Objection,
ruled
right,
on?
yeah.
Okay.
If I can elaborate
Yeah,
on that, Mr. Chairman.
Sure.
These are board decisions. And so when the chair makes a ruling, that's going to be presumed to be the entire board's ruling, unless it's going to be presumed by unanimous consent that the whole board agrees. So agree, or if you want to talk about it before the ruling is made, just raise your hand. And that's perfectly acceptable, because we want it to be each of these decisions of the board to be the board's decision. You know, so each ruling of the chair, if you want to talk about it, just get recognized, and it'll be talked about, and it'll be decided by a board vote.
thank you. Yes, that's helpful. And then one final procedural thing is that no one would approach the witness except when the witness needs to see an exhibit. So it won't be like Perry Mason on TV. If you even remember Perry Mason. Dating myself.
No walking around in the
Yeah.
promenade. Yeah.
No, right. None of that. So, and as I noted before, we've got the oath or affirmation on the second page there. It comes right out of the state statutes and maybe even the Constitution.
What's the difference between,
Oath or affirmation,
correct, I'm just
You don't
familiar
wanna-
with the oath.
you're sincerely non-religious and you don't want to
I see.
swear
I gotcha.
on a Bible or anything like that. There's an alternative available for you.
Oh, yes.
I mean, I was going to ask that same question. Looks like if I want to, I can pick 3 rather than 2.
I think you administer the second one, and if they disagree, then you would administer the,
Second one, yeah.
Right. So,
Second.
'Cause I don't
one.
want to, second one wouldn't appeal to me because I don't want to force people who don't believe in God
Oh, well,
to
then it-
swear. I think,
Well,
just forget that.
yeah, it's a good point. And you can always ask, do you prefer an oath or affirmation?
Oh, either one.
Yeah.
But I have to show them what the difference is. Here's the difference, you know.
Or
if you
could
read it, it says.
read it to them.
Every person it's their decision if they want to declare that they have conscientious scruples against taking the oath.
Right. Most people are familiar from popular media and culture with the, do you swear to tell the truth, the whole truth, and nothing but the truth, that kind of thing. People
Right.
are used to hearing that. Those who would be uncomfortable with it are probably already on the alert. I'm not going to say that, so it probably isn't going to be an issue.
In
So,
many years, I have not seen this be an issue. I agree that you should use the "So Help Me God" version. If they object to that, they'll tell us, and then you use the other one.
Right.
And so the process is, you say, state your name, give us your name, state your name, spell your last name for the record, raise your right hand, then you read this, do you solemnly swear? And then they will answer the question, and then that's done.
And if they say they
So they,
don't want to swear, you can switch to the
well,
affirmation.
shouldn't I point out that they have a choice?
I think it'll go smoother, faster if you
Don't point it out?
I mean,
Okay.
they'll point it out, I
I'll
think.
find out,
Yeah.
yeah. Because it probably would annoy me.
You might get bogged down with a lot of people saying, gee, I don't even know what is that affirmation? And you'll have to answer each
Exactly.
one. Yeah. So,
I kind of, and that's is a little odd, but we can do it that way. I just as soon give the person a choice, but apparently that's not the procedure.
well, I don't think there's any required procedure, but
Right.
I think it's going to go more efficiently if we just assume the default is, do you swear to tell the truth? And I think those who don't want to swear are well aware of the fact that, oh, no, I'm not going to do that. And they'll stop you and they'll say,
Well, I wouldn't be, I don't think.
really?
Oh, yeah. Difference between swearing and not swearing. I mean, this is the first time I've run into it, this contrast.
Oh, really?
Oh, God, yes. Oh, God, yes. Don't you like that? All right, we got God back in. Okay. Good idea. I'm totally happy with that. But, yeah, offhand, I would think most citizens don't watch those or are dead who watch those programs. And I think that if there's a choice, I really want to give them that. Say, swearing involves in the name of God, and the other one doesn't. Do you prefer one to pick which one you want? Is what I would like to do.
What I might suggest then, Doug, is just ask if they prefer an oath to tell the truth or an affirmation to tell the truth. And if
I
they,
might not know the difference, and I have to
yeah,
explain
then
it.
they'll probably ask you, and, yeah,
Right.
well,
Okay. All right. And I just want to do this in a fairly open
won't be
way.
any sanctions if
Because
you,
I remember I taught philosophy for only 53 years, so I do not try to assume someone's views.
yeah, there
I
are
have my own, which
dangers with that, yeah,
Right.
there can be.
okay.
Anyway, so do we, with Doug's comments on the oath versus affirmation in mind, as to the whole that we've discussed so far, do we have consensus that this sounds like it could work for us? Any comments, any concerns?
So we're not, are we not going to be able to deliberate as a body on the questions that are going to be asked? They're, like, we're more or less going to be, we'll be at the hearing, you'll provide the questions as witnesses are set up to respond, and then if we want more clarification or if we want to elaborate, I plan on having a list of my own kind of like terms and things I would like to understand better.
That's a good
And
idea.
And if you, I guess if you field the questions that you field, and I have something that's maybe either in the same direction or not, then we would just take it upon ourselves to raise our hand and ask those questions.
Yeah, I think after you hear the questions that I ask, either I will not have addressed something that you want to address. Maybe I will, and maybe you'll see no need to raise your hand and ask questions. But another alternative is that I'll address something and it doesn't quite fit what you had in mind, and you may decide at that point that you want to ask something to clarify that.
Would you like us to wait until you're done asking your questions, though? Just curious if if it sounds like you're moving on to a different topic with the same witness, if you want us to jump in and say, hey, I still have a follow-up question on that same line of questioning. It's just sort of how, or if you want us to wait till the end to ask.
I guess I would prefer to wait till the end if
Okay.
it's not a big deal.
Yep.
See what all is there.
Okay.
There are times in what I've been working on so far where the organization is such that I have a reason for beginning to talk about some specific fact and then coming back to it later on.
Yep.
So that could happen.
Yep.
We can probably position our line of questioning to be, if we're referencing back to something that had been said or to clarify on a question you had asked, we could say referring to this point that the chair made, could you clarify X, Y, and Z?
Sure.
Okay.
Yeah. Sounds good.
So,
Yes.
Mr. Chairman,
Yes. Attorney Larson.
just two points I want to make. One is these are questions. We shouldn't be making statements. So the chair has questions he's going to ask the witnesses. And then you can follow up with additional questions if he didn't touch on something you had. But it's only questions. We should not be making statements. And that's the first point. And then the second point is it's critically important that we remember our role as investigator. We're conducting an investigation. We're not taking a position. We're not advocating. We're trying to gather information. So if you are going to ask a question, sure that it's from that, coming from that place of truly just trying to find out the facts, right? It's not to be cross-examining somebody to prove a point or something. That's not what we're doing.
Right, thank you.
Yeah, the goal then is not to be prosecutorial. We're just really assessing information and clarifying.
Making sure we get
Right.
the facts on whatever it is we're looking at. We want to get to the bottom of it. We're not trying to pin something on somebody. So we always need to keep that in mind. We don't have a prosecutor. We are an investigative body. So good questions. Anybody else? Any other questions on this?
No, maybe just more of a comment to help us go through it. That generally, when you're taking notes, I always like to divide my piece of paper in half. You're taking notes of what is being asked and answered, and you're writing, this is just what helps me. I'll write additional questions off to the right, kind of following that, and then seeing, again, making sure those questions are answered so you can kind of go back to see that. That's just what helps me, if that makes sense.
Especially in this format where we're going to follow after a series of questions may be asked.
Exactly. So you could kind of see what the testimony was, and then you can write your additional questions off to the side and see if they are answered later.
Yeah,
Suggestion.
guidance, thank you.
Thank you. If we have general agreement, I mean, one thing we might think about is before trying to address what order we want to hear the witnesses, we could split the question. Are we okay with the procedure? Have a vote on that, and then we can talk about who would testify and when, in what order. And what's the board's pleasure on that? Should we split it or vote? Or
I would like to take the procedure separate, then yes.
that makes sense to me.
Yep,
Yeah.
I agree.
I will move that what we've laid out here on this suggestion sheet be adopted as the rules for conducting the hearing. Is there a second?
I would second.
It's been moved and seconded. I think we've had our discussion already. Seeing no objection to a vote, let's move to that vote. All in favor signify by raising your hand. And it passes unanimously. Now we have the question of what would be the order for calling board witnesses? And of course, even to list the witnesses, I have them in a certain order. And a couple of vague ideas went into the order that I put down. One is, one idea that I had in mind was trying to do things to a certain extent chronologically, but not strictly that way. You notice that I have Chief Matt Barnes down as the first witness. Well, that's because he's the chief of police. He's got a big, heavy responsibility for keeping our community safe and enforcing law. And, I think he would appreciate, I would appreciate if he can get back to work as soon as possible and not be waiting around in here. Now, that's not to say that everybody else on this list isn't important as well, but, public safety is a pretty big priority. So that's my thought on listing Matt Barnes first. And then I've got, I think a lot of the others here are from Gerard Klein through Leo Gao. I think they're pretty much chronological order for what we're interested in finding out about, what their role in this might be or what contacts they might have had that we might be interested in. So that's why those are listed the way they are. Lisa Rasmussen is listed after Leo Gao. because I think that it's likely that there may be more testimony, more questioning for Alder Rasmussen. And then the witnesses who are likely to have the most to say round it out: the city clerk, the city attorney, and the respondent if he's testifying. So that was my thinking there. Anybody have other thoughts on that subject?
I think additionally, the amount of content that we would probably like to discuss with these individuals is represented well here, because there's what has been submitted as far as evidence and what, or lack thereof. This is a good timeline for that as well.
Yeah, right. Based on the responses we've seen to our investigation so far, that was the idea. All right. Is there a motion to approve this order of witnesses?
Motion.
Been moved by Jesse. Is there a second? I'll second it. Is there further discussion? Seeing none, all in favor signify by raising your hand. Once again, we have unanimous vote. Bear with me a second here, a little technical issue. I wasn't raised with computers. All right. Okay, I think we have completed what the agenda calls for. Is there any other business to come before the board?
Well, related to our agenda items, we haven't talked recently about what happens after the hearing. And we can wait and see whether we want to deliberate that day or whether we want to adjourn to another date to conduct our deliberations. Our deliberations are likely to be in closed session, I assume.
Likely to be what?
In closed session.
Oh, yes. Mm-hmm.
So I guess my suggestion is we can reserve that opportunity on this agenda to go into closed session to deliberate. We need to, I believe by our rules, reduce this to writing, and I believe it says we have to do that within 7 days. So there's going to be some drafting time needed to put that on paper. And my hope is that we could deliberate at least long enough to give me and anyone else who's going to work on those, on the written decision, some direction in order to produce some things to bring back to you within a week.
Right, that's the way
So you,
I've envisioned it. We don't know how long we're going to need to deliberate. If we don't deliberate for a particularly long period of time, we can maybe even begin discussing the drafting or giving the direction that you referred to. If it's a very long deliberation, I'm not sure. Maybe you can advise us on how we handle that. I mean, it's...
I think the question here too is about scheduling. So he's saying that maybe once we're finished with the hearing, then we would go into closed session for deliberation on that Friday, which I think is,
Right.
it's probably a good plan to use that time. Could we then decide during that closed session when we would meet, or do we need to set something up for like the next meeting that we would have?
ahead of time.
Well, I think we'd have to do that in open session.
Okay.
Talk about scheduling another meeting.
Is that something we can do after we've had time to deliberate on that Friday and then come back into session?
Yeah,
Okay.
deliberate, come back into closed session, or into open session, and then talk about if
Sure.
Next meeting.
Depending
Just-
upon,
we need another meeting.
just looking at my calendar for the week after, I think I could find time for sure. So I guess pending nobody being out of town
Yeah.
or just an extremely bad schedule.
No, my schedule is fairly wide open, but again,
Okay.
it's going to be later in the days. Tuesday, Wednesday, Thursday, I can't do it until after 4:30.
Well, we'll work it out then, but there would be some time.
Yeah,
Yeah.
I mean,
All right, because it
I'm open
does,
all
it does
those
seem to be
evenings.
wise that we go into deliberation to figure out what's going on and then how we might finalize it. I think that it's going to be a two-part process, no matter what we do.
correct.
So I think that's definitely something we should have as a plan.
yeah, it absolutely has to be in the plan that we deliberate and then we issue written findings and conclusions. Whether there needs to be another meeting, I don't think we need to meet when we issue, well, we do have to adopt the findings and conclusions, that's right. So we will have to have a meeting for that part of it as well. Yeah. But I would think we could address that on the day of the hearing.
Right. I mean, so you're saying there should be a possibility, like, it could be that in our discussion, we realize we're going to have to write up some things, going to have to develop them, and that would be for the second meeting. But it could be in that meeting, we come to a conclusion.
Right, I would anticipate in deliberations,
Right.
and hopefully they won't have to take forever, but in
Right.
deliberations, we would come to some conclusions, verbally at least.
Right.
And then that has to be converted to writing within 7 days.
Being respectful of that 7-day period puts us at the 17th would be the latest we would have that finished. So would we want to shoot for Tuesday, Wednesday, or Thursday that week to meet, to just to put that time on the calendar in case there are further deliberations or discussions we need?
Well, what dates are those?
That's the following week could be the 14th, 15th, and 16th are the days that, like, again, I would have to be 4:30 or later, but I can do it those 3 days. And I just think that Thursday is pretty late if we're going to have anything for Attorney Larson to draft, so.
Yeah, I think let's see how the deliberations go on the 10th. My thought is we may get far enough along that we'll only need a day to come back and look at, go through the written document. And I think that could be Thursday, the
Okay.
16th.
Right.
Wait a minute.
So if we would pencil in a date, that would be my preference. And if it's after 4:30, is the room available, Cody?
Can you repeat the date again?
16th,
Thursday,
The
the 16th.
16th.
Yeah, I would prefer not to. I do have,
What's that, Robin?
the Thursday, I do have an event
In the evening?
in the evening.
So what time are you thinking?
I'd prefer not to do it on Thursday at all.
Oh, okay.
I mean,
Sure.
I can
Yeah.
cancel my event, but if there's another date we could look at, I would like to.
Would Wednesday be better? And
Wednesday would be better.
I would, yeah, for sure, until 4:30, I'm not available, but after that, I'm wide open.
Yeah, and I'll make myself available.
Yeah, I could do Wednesday at 4:30.
4:30 works.
Wednesday, the 15th. What are we limiting it to? We want to be done by 4:30?
No, we'd start at
Start
4:30.
at 4:30, yeah.
But
If the room,
it's not likely to have to take a long time.
exactly.
Let's hope not.
Yeah.
God, this is taking long enough.
Just taking a vote
Oh,
on
my
something that's
God.
been drafted.
For everybody, yeah.
Sure, we just need a
Likely
date.
what we're going to have.
Yeah,
yeah.
and a
So we'll
quorum.
kind of pencil that in.
Yeah.
So Wednesday at 4:30, is there saying? Or 4?
Yeah, Wednesday, 4:30, I think Robin said.
I have a 6 o'clock, but if it's remote, it can all work.
Mhm.
Yeah, and I would think for that limited purpose, there should be no problem with that. Thank you for bringing that up, Attorney Larson.
As
Got things a little
14th?
more definite.
4:30 PM, okay. That's all right.
All right, anything else? I would entertain a motion to adjourn.
I will so make that motion. I'll make that
Well,
motion.
Yes.
Mr. Chairman,
Yes.
Attorney Erlandson has raised his hand.
Oh,
Okay, Attorney Erlinson? I don't think you've got your audio on.
Yeah, sorry, I was hitting the wrong mic icon. The board has not published minutes of any of its meetings since the February meeting. There were decisions made on substantive motions at the last hearing as to which there is no record. There was an earlier motion as to which the board issued a written decision that was countersigned by Deputy Clerk Hart. Is any of this procedural material going to be made available to the respondent? Or shall I go by my notes of this meeting?
Go ahead, Cody.
My plan was to have all the previous minutes available for approval at the hearing as an agenda item.
And we've also got,
So I won't see it until October 10th when it's voted on.
So, Mr. Chairman, as to the rules, I think it would be important for Mr. Erlandson to see those rules. So if you can have
Sure.
those sent to me, I can forward them to him.
certainly.
And Attorney Hall may also be interested, so I'll get him to him as well as the complainants counsel.
okay.
That sounds good.
And then the order of witnesses that was the subject of discussion, so I can not duplicate efforts. I would like a copy of that as well.
Certainly. We'll do that. I'll get that to you, Attorney Larson, both of those, and then you can get them off to Attorney Erlinson. Okay, anything else?
Okay.
I'm not seeing any.
Oh, we need a second for the motion for adjournment. I would second the motion
Which motion are?
to adjourn. That Doug, he moved.
Adjourn. Oh, yes,
Yep,
thank you.
I would second that.
Looks like we can proceed with that now. All those in favor of adjournment signify by raising your hands.
Okay.
And we got another unanimous vote. Meeting adjourned. Thank you very much.
Thank you all.